All good lawyers want to win. As litigators, we all have the same goal: gather the right evidence to help our clients. If you ask 5 different lawyers what they most like about being a lawyer, you'll probably get 5 different answers. Some people would say the intellectual challenge, or maybe, if they're feeling honest, the prestige and the salary. Or they might say that they love the travel. Some lawyers go all over the country or even the world to participate in trials or business deals. Or maybe they like rubbing shoulders with business leaders, politicians, athletes, and other celebrities. But if you ask a lawyer why they chose to become a lawyer in the first place and why they stuck with it, you'll probably hear something like this: I'm passionate about uncovering the truth. I care about working for justice. I want to help my clients. Those goals can be achieved in lots of different ways because, as we litigators know, law itself is also an incredibly multidimensional profession. There's international law, criminal law, contract law, property law, equity and trust, constitutional law, and the list goes on. If you're interested in one particular area, there's a special niche somewhere just for you. And if you ever do decide to take your career in another direction, the skills that are fundamental to being a lawyer, like clear communication and analytical thinking, research skills, and sound judgment, are also extremely valuable in other professions. I've been a lawyer for over 40 years. I've worked with some great litigators and some not so great ones. And you know what set the really great ones apart? They're passionate about the work. Good lawyers live and breathe the legal profession and do everything within their skills to win their cases. For me personally, joining this profession was one of the best decisions of my life because I'm passionate about the law. I believe that lawyers have a unique power to help people. While we can't turn back the clock and prevent an accident or an injury, a bad business deal, or a more personal loss, as lawyers, we can help balance the scales for our clients so they can go through the rest of their lives with a greater sense of justice. There's nothing more satisfying than using one's analytical skills and knowledge to identify the legal issues, discover the details of a case, and reach a resolution. Over the course of my career, which now spans several decades, I've had many different roles. I practiced law in different areas and learned a lot through my journey to become a better lawyer. I've been in private practice, and I've worked as a prosecutor, and I worked as an assistant United States attorney handling civil matters. In that time, I never lost my passion for the profession, and I became a better lawyer. But something else happened over the course of that 40 years. More and more, there was a fundamental shift in the practice of law. The evidence that used to build a case started to look increasingly different. More data and information began to be stored and exchanged electronically as technology became more and more embedded in the practice of business and in the fabric of our daily lives. No longer was paper the mainstay of our evidence. Evidence, just as so many other things in our world, has gone digital. And there aren't any exceptions. No matter what branch of the law you're in, every single case now involves electronic evidence. The paper trail isn't just on paper anymore. Information is no longer mostly stored on paper. Now every email, text message, or trip tracked with GPS could be important evidence. Just think about that for a moment. It makes sense, doesn't it? Almost every moment of our own day involves and is often recorded electronically, electronics of some kind. All of that evidence and activity, whether it's email, text messages, social media posts, artificial intelligence, algorithms, website search history, or video conferencing, could make or break a case. Electronic evidence is everywhere, but there's a problem. Many lawyers don't take the time to understand the power of electronic evidence and the legal issues that apply and suffer because of it. As a lawyer, you might be thinking that all of that electronic information presents a problem for you. There's just too much of it. And you're not a computer scientist, you're a litigator. But I'm here to tell you that problem is also an opportunity. The explosion of electronic information and how to discover it, manage it, and use it effectively in cases or counter its use by the other side can be daunting. But it's also a huge opportunity for good lawyers to better help their clients in significant and meaningful ways. The real problem is actually that too many litigators just can't see the opportunity. Electronically stored information, or ESI, has been in the legal news for the last 20 years, especially after the passage of the Federal Rules of Civil Procedure in 2006. But even now, a staggering number of lawyers still say things like, "Oh, I don't need to learn about electronic evidence because the opposing side will disclose responsive ESI to me. They have to." And that's simply not true. You only have to look at the number of cases where sanctions are imposed for failure to disclose ESI. Never assume that you know all you need to know, or that your opponent won't use what you don't know to their advantage. Let me give you some examples. In the seminal Zubalek decision, a former female employee brought a gender discrimination and retaliation claim against her former employer. At issue was the discovery of electronic information, specifically electronic mail, in the control and possession of the employer. In the restoration effort, the parties discovered that certain backup tapes were missing and that emails had been deleted. As a result, the judge ordered an adverse inference instruction against the defendant. The jury found in Zubalek's favor on both claims, awarding compensatory and punitive award in the amount of $29.3 million. Also, don't forget that this duty also applies to plaintiffs who fail to preserve ESI. Plaintiffs failing to preserve ESI has resulted in dismissal of many cases where social media content or other electronically stored information has not been preserved. So ethically, what are your responsibilities? Under the ethical competency rules, now enacted by approximately 40 states, the comment to Rule 1.1, which is entitled Competence, requires lawyers to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, and engage in continuing study and education, which, without a doubt, requires an attorney and those they supervise to be able to apply technological concepts and legal principles to the identification, preservation, and disclosure of ESI. Why are the courts and bar associations so concerned with attorneys preserving electronic evidence? This is answered in many court decisions and highlighted in the United Medical Supply case, where the court stated, "Aside perhaps from perjury, no act serves to threaten the integrity of the judicial process more than the spoliation of evidence." I've been in the profession a long time, and I've seen plenty of otherwise perfectly good lawyers make unnecessary mistakes. So it worries me when I see that the number of cases involving ESI and spoliation sanctions hasn't decreased. I review over 1,000 cases involving ESI every 6 months from both federal and state courts, and the number of sanctions issued for non-preservation of evidence has actually increased. I see cases where the courts have awarded adverse inference instructions, dismissal or default judgments, attorney fees, preclusion of evidence, and many other sanctions, all because the litigators involved didn't handle ESI as they should have. So I decided to do something about it. I became not only a lawyer, but an educator. Over the last 20 years, I've written several books and taught classes in law schools, law firms, government agencies, corporations, and online to help more people in our profession understand ESI concepts, the risks that come along with them, and how to avoid common mistakes. Assuming that you don't need to pay attention to electronically stored information is a costly mistake. but it's a mistake you can protect yourself and others on your team from making by taking the time to learn. First, just let me be clear. I'm not saying that you have to become a computer scientist. You're in this profession because you're interested in law, and that's the way it should be. I am saying that as a lawyer in the 21st century, having a working knowledge of electronic information is a must. Whether you're just starting out mid-career or nearing retirement, my educational resources can help you learn what you need to know. It's easier than you might think. However, because the complexity is only going to increase, and just like you've worked to understand and apply new concepts in other areas of your practice, like accident reconstruction or medical procedures in a medical malpractice case, you can understand and apply concepts like metadata or not reasonably accessible ESI in your practice. Building the skills to use electronic discovery and evidence in your case begins with a simple online assessment. Once you know where you're starting from, take the courses that best meet your needs. Be confident you've done all you can do. When you put effort into educating yourself about ESI, you don't just protect yourself and your team from that terrible feeling of letting a client down or making a costly mistake. Armed with the skills to handle digital evidence, you can also provide advice to your client in other situations. Say, for example, that you have an employee who took electronic information that needs to be recovered, or your client brings you an abusive artificial intelligence case. Are you prepared to assist your clients? Understanding electronic discovery means you'll be ready with the right legal advice. Understanding digital evidence is also a powerful negotiating tool. Because so many lawyers ignore requesting electronic information, and let's just say it, are generally uneducated about technology, those same lawyers are intimidated by the thought of opposing counsel getting that information from their clients. Knowing how to handle ESI means you'll be more prepared than the other side. Whether you're a veteran of the profession or still in law school, you have an opportunity in front of you and a critical choice. Because when you choose to invest in education and skills to engage with electronic discovery and evidence effectively, no matter what your role is or what type of law you practice, you'll be a better advocate for justice and a better advocate for your clients. What will you choose?